Sometimes I get asked, what is the biggest mistake you've seen with I-601 or I-601A waivers? That is an excellent question. So we're going to talk about that because I want to make sure you avoid that. You don't fall into that pitfall today. And I'm going to talk about a case study as well so you can see, more importantly, what to do right. Hi there, this is Kosher Ranchod from the Ranchod Law Group, representing clients throughout the 50 states. Been practicing over 20 years, and I'm hoping to deep dive today into this great topic of the I-601, I-601A biggest pitfall to avoid. We had a client who came into our office. They had hired another attorney, and unfortunately, the case was a complete mess because of what had happened. The case was filed. It was an I-601 waiver in this situation, and the waiver was filed completely by itself. It was not filed with any underlying application. So when you're filing an I-601 or I-601A, it's really important to note that there needs to be an underlying green card application. So that can be in the form of the adjustment of status application, which you can concurrently file with the I-130, the 485 in most situations, the I-765 work authorization. So in all of these situations, you must have that green card application, whether you file stateside within the United States or you file outside of the United States as well. So in this situation, that was not the case. They had no application. In this situation, the I-601, you couldn't do anything with it. Now, I've also seen this happen. We had another case where a client went to a notario. A notario is someone who you might think is able to practice law, but they're not. They don't have the license to practice law in the United States, and it's confusing because in your home country, that sometimes means that that could be an attorney, but a notario is not someone who could practice law. And this is someone case who was messed up because that notario told them to leave the country when they shouldn't have left the country. They should have just filed an adjustment of status in the United States. So it really depends. Every case depends upon your unique situation. It's really important to make sure that the law is applied appropriately. So getting back to the situation here, if you're filing for I-601 waiver and your spouse, for instance, is outside of the United States, in that situation, you still have to have that underlying application. So what I previously described was the adjustment of status process. However, in this situation, you have to file the I-130 in the United States. That's the petition demonstrating the bona fide relationship. Then you have the process go to the National Visa Center. That's a little bit different than the I-601A waiver, where then you would file the I-601A legal brief. In this situation, you would file the documentation and DS-260 form, I-864 form, and anything else that the National Visa Center asks. After the National Visa Center approves the application, National Visa Center is very tricky. They like to keep on sending things back. If you have one little thing that they don't like that they feel is not correct, they'll keep on sending it back. So that's really important to get that down because you want to try to minimize the delays, of course, because you want your loved one here as soon as possible. So National Visa Center, after that, you would be scheduled for an interview. And then at the interview, they would say, well, you're not inadmissible for instance, if you've overstayed for 10 years. Now, this is the I-601 waiver where your applicant already outside of the United States. So the I-601A, which is different than the I-601, the I-601A allows you to file the waiver in the United States, but sometimes your spouse might already be outside of the United States or they were put into expedited removal. So every case is different where your applicant could be outside of the United States. So in that situation, then it's a different process. So right now I'm talking about the I-601. For instance, if you had overstayed in the United States for more than a year, you would be subject to the 10-year bar. So if they would make that finding that you're subject to the 10-year bar and then request that you file for an I-601 waiver. You might be wondering, how long is it taking? Well, it's taking over 2 years. They were not taking that long. It was taking a year, maybe about 9 months ago. And then they significantly increased those times. The American Immigration Lawyers Association, which I'm a member of, has filed a lawsuit for the I-601A waivers, which are taking over 3 years right now, which is an extreme hardship in and of itself. So we're hoping to see those times come down, but that's about what is taking right now. Then you have to file the I-601 waiver and wait for that to get approved in order to come into the United States. So I talked about what did not work. Let's talk about what does work. Go over a case study for you so you can get an idea of what is the appropriate way to get a case approved. And this is going to talk about the extreme hardship. So in both the I-601, I-601A, you need to just demonstrate extreme hardship. It's not just mere separation. In this case study, we had a client who entered the United States when they were a teenager. He was from Mexico, he was self-employed. In many of our cases, what happens is you have someone who's a breadwinner out working, and then you have someone who's staying at home. So here, the wife was staying at home. The applicant for the I-601A waiver was actually going out and working. Both people, of course, it's a team, as you know, in a marriage, you need both people to make the household work. And if the wife was not going to be here in the United States, then it would be a huge problem because there'd be no childcare. And she was also taking a technical course that she wouldn't be able to do if she had to leave and go to Mexico. Now, another big argument that we made was the fact that their healthcare coverage would be disrupted because the state of California was covering their medical care. So they didn't have to pay for office visits, they didn't have to pay for their health insurance. So imagine if they did not have that in their home country, and that's what we painted the picture in our legal brief, making that argument, which ultimately led to an approval. But we didn't just argue that, we also talked about family ties as well, because she was taking care of her parents who were older, and her parents needed her support. Finally, we talked about how the possibility of the husband leaving, or if the husband left, that would give the U.S. citizen spouse significant anxiety. This was a form of mental health hardship. So we made all of those arguments to get the case approved, and now our clients are able to live in the United States permanently. Want to make sure you do things the right way. If you have questions, post them below. I try to get it to as many as I can, and I just want to thank you for taking the time to watch this video. If you thought this was helpful, you check out our other case studies to learn more about what's working, and make sure that you share this with a friend that may need help so that they can get the information they need as well. And by taking the time to watch this video, you're bettering yourself. By bettering yourself, you're bettering your family. And by bettering your family, you're bettering the world. Thank you. Bye for now.